Okay, so after this, we turn to the Wallenberg lecture. Now, before I introduce our speaker, our distinguished speaker, let me just say, 2 words about the Wallenberg lecture. So, ECGI had an annual lecture for many years, and then in 2020, we were going to have our annual conference in Stockholm. And the Wallenberg family has been supporting ECGI from the very beginning. They have foundations that are one of the largest scientific funders in Sweden, and they've actually donated Wallenberg Hall at Stanford University, amongst other things. So they're, on the one hand, philanthropists. On the other hand, they have investments, and they invest in particular through a listed holding company called Investor AB and an unlisting vehicle called FAM. And they consider corporate governance as really part of their DNA. So on the one hand, they're scientific funders. On the other hand, they are very much involved in corporate governance because they actually put people on boards. They take responsibility for the investments that they make. And they've been supporting ECGI, as I said, from the very beginning. So to mark that they're Swedish, and to mark this, our gratitude to them, we actually proposed to rename the annual lecture the Wallenberg Lecture and kick it off 2020 in Stockholm. Except that, of course, there was this little COVID issue, so it moved online. So we still kicked it off in 2020 with Oliver Hart. And the discussant of Oliver's inaugural Wallenberg Lecture was one Anat Admati. The speaker of the lecture is chosen by the ECGI Research Committee, not by me or by Herman. And the ECGI Research Committee unanimously suggested that this year's speaker should be Anat Admati, and we're very grateful that she accepted to give the Wallenberg Lecture today. Now, Anat, you can read her CV. Let me just say 2 particular words. So, in corporate governance, she and her co-author Paul Fleiderer, they really wrote the paper on voice and exit. This is now, it was important at the time. Today, it's really become super important because the whole debate of whether you should engage or whether you should sell, and by the act of selling you can actually influence organizations, is really important. And this morning, for those of you who've just joined, we had a business meeting of ECGI, and we decided that we would introduce dues or fees for our research members, who none of them actually, maybe 1 or 2 were there, so they didn't have much of a chance to exert voice, but they do have the possibility to exit, okay, by leaving. And I can tell you, when we took that decision, we were thinking quite acutely about that possibility. So Anat, your theory really came into action this morning. Now then, so instead of continuing on that track, like, for example, Doron Levit, who was honored in the prize today here, Anat got distracted by the financial crisis and then devoted quite a few years together with Martin Helvig, another one of our fellows, to think about banks. And they've just put out a new book, which she's going to present in Frankfurt, which is presented, and she's going off this afternoon to Frankfurt to present it there. But today, she's not going to talk much about banks. I think a little bit about banks. You can never avoid banks. But she's going to talk about whose governance, whose corporate governance, which is a much broader topic. And Anat, we are delighted that you are here and that you've accepted to give this lecture. And it is being recorded. And thank you very much. And we look forward to hearing what you have to say. Thank you.
Thank you, Marco. And I'm really delighted to be here and honored to be presenting this lecture. And so I'm going to actually do it through my personal story, and indeed starting with what Marco was talking about, my corporate governance research, before my career, my life changed. So before that, this was the first corporate governance paper, which was motivated by pension funds becoming active in providing sort of monitoring to other smaller shareholders. And so we were wondering how that affects the sort of fact that they can affect the payoffs, affects what they hold, the diversification, other things. And so we solved for that and discussed it in this paper with Joseph Zechner, who was spending the year at Stanford at that time. And then the next paper was the one that was just mentioned, that came out right after the financial crisis, where we had a whole agenda on the sort of microstructure of impact of governance, shareholder governance anyway, because that's where corporate governance tends to be. Shareholder governance, shareholder board, managers, et cetera, et cetera. So can the manager be changing what they do because of a threat of exit? How would that work? If there's a price impact, does it actually work? All of that. So then came September 2008, and these were some of the headlines. All of a sudden, my corporate finance hat was challenged because I was always telling my students how wonderful the financial system is, and then it didn't seem so pretty. And so what happened that it needed these bailouts, that it was going to take the entire economy down, and that in fact it did cause a great recession despite all the bailouts. So something was wrong, and I got curious about it. I wasn't a banking expert. I was just in corporate finance, and you always think banking is someplace else, special. And I wanted to know just how they are corporations after all, so how different and how similar are the banks to other corporations? Was everything I knew about corporations different? And if so, how? So I liken it to falling into a rabbit hole. Things got curiouser and curiouser for me. People were saying things I didn't understand. I didn't understand the policy. I didn't understand why it had to be the way it is. Here I'm going to, rely a lot on Matthias, having given you some background, even though, as he was pointing out, I'm a bit more extreme and less accepting of what's going on. Two books that I would point to, and they're related to culture, is Michael Lewis's The Big Short, which was he tells it with characters. We can't even publish with the same publisher, Norton, that sells millions of copies of Michael Lewis's book, because we're just academics trying to teach corporate finance to the public, and that's much less fun than reading The Big Short. But what I want to point to here is the epigraph of The Big Short. In the epigraph of The Big Short, Michael Lewis is reflecting on his first book from the 80s, and it is about culture, the Liar's Poker. And Liar's Poker was telling the stories about the crazy culture. And here in the epilogue, he's reflecting on the fact that Salomon Brothers and many of the other investment banks moved from being partnerships to being corporations, and in fact public corporations. I recently actually talked to somebody who was a partner at Goldman Sachs at the time Goldman Sachs moved from partnership to a corporation. And the story I was told was in a partnership meeting of Goldman Sachs, the CFO, the chief financial officer of Goldman Sachs, told the partners that some of them are worried that the bank will have to be more transparent now that it's public. And his words to the partners were not to worry. So I will talk about that. The banks are very, very opaque. The modern banks, anyway. So, but what's important is that Michael Lewis is saying here that this was the moment at which the people whose money was put at risk, the shareholders, lost touch and understanding of what was being done with their money. So he is talking here about the opacity and the ability to take risk with shareholders' money without the shareholders really understanding what's going on. Now that could happen through chains of asset managers and other intermediation. And then the final line is the line that we take also in our book. The problem was not that Lehman Brothers wasn't bailed out, which many people said it should have, and maybe it should have given where it was, but that it had been allowed to succeed before. And that was the problem with the entire system, that it was allowed to get as fragile as it did. Another book written in 2010, shortly after the financial crisis, and before we caught our breath and figured out what to do. At that point, we were still writing petitions to policymakers and trying to do other things than trying to explain, capital structure to the lay audience. This is a book from an ex-derivatives trader who talks very much about the culture of the banks. So this connects to the themes of this conference. So the first paragraph is about risk-taking and risk-shifting, saying, they risk the capital, the equity, and on the upside, they get big bonus and ROE and all that. On the downside, it's somebody else's problem. And then he says, they can always play the systemic risk trump card. It's the ultimate of capitalism, the privatization of gains, the socialization of profit. So this is about where the upside is, the magnified upside from leverage, and the downside, not with me. Okay, I'll take my bonus, and then it's going to be somebody else's problem. The second paragraph from this book is about lies. It's about deception. He says, beautiful lies are the lies that you want to believe. The salespeople lie to clients, traders lie to sales, and to the risk managers lie to those who run the place, correction, those who think they run the place. The people who run the place lie to shareholders and regulators, clients lie mainly to themselves. So he's talking about lies everywhere in the context of derivative trading, okay? And he describes it in great detail in that book. We wrote a book that was mentioned just now, and the reason I'm putting all these great praises from the biggest, best economists in finance and economics, starting with Ken Arrow, is, not necessarily to brag, but actually to tell you that it doesn't matter how many great economists endorse your book. You can't win in the politics of banking. That's the problem. So the book had... I'm highlighting here, this is the table of content of the chapters. Most of it is about what Matthias talked about, which is about debt and equity and leverage, a subject of which I learned a lot afterwards from understanding the dynamics of leverage, the addictiveness of leverage, and the fact that leverage indebtedness is fed by guarantees and liquidity support. And that's why banks hate equity with such a passion, because they have so little of it to begin with. And that's the symptom, a part of the symptom of what we see. Two chapters that were specifically on governance in this book, which was not about corporate governance, it was about the rules of banking, are a chapter called Paid to Gamble, which is about compensation structure in banking, and it's about front-loading the upside and leaving the downside for later, in the sort of I be gone, you be gone kind of by the time the risk materializes, or by the time, as the rest of this lecture will go, by the time, the fraud is discovered or any other misconduct. I'll be gone, you be gone, it will be okay, okay? So this whole notion, and the epigraph here as well is what they say about how they need to have a certain ROE, which is completely crazy in banking and doesn't fit anything we know about in corporate finance. It's difficult to get a man to understand something if his salary depends on not understanding it. And that's a saying that applies to why they refuse to understand things that are very bread and butter in finance, like that risk got to be borne by somebody on the balance sheet, ideally. And they will just say things that are just completely fallacious from a corporate finance perspective. So in that sense, I fell in a rabbit hole because all of a sudden the basics, absolute basics of corporate finance did not apply. It was like a different island, a different planet. And they speak a different language, a different lingo, all about liquidity and channels and risk appetites and all kinds of lingo that goes with that. The final chapter of the book was kind of a broad governance chapter in which the epigraph comes from we were looking for how to finish it, and it was going to be about governance broadly, which is why it's called Other People's Money. And Other People's Money include how the government treats taxpayers' money and how it allows itself to regulate banks poorly and then bail out, directly and indirectly in all kinds of ways. And this is what the Barclays CEO was saying. The scandal of the day at the time was LIBOR. And we ended the book by wondering what that was all about. So there was a little bit of a misconduct in there, which the rest of the book was not at all about, law enforcement. It was about the law itself and about the specific regulation about leverage called capital regulation and the risk weights and all the other stuff that Matthias talked about. But this was a hint that, there was more going on than this. This was a quote from Paul Volcker that I discovered later, and when I am only given like 5 minutes on a panel in Davos, I will use the word bullshit that he said about the threats that are always made. I just paid a dividend and now I won't make a loan if you make me, retain my earnings. How so? All bullshit is what he said, and so we spend a lot of time on that. In a review of our book, Martin Wolf basically summarized it the way we did. Banks are not special except for what they get away with. So the specialness is really not a good one. Obviously, every industry is special in doing something that we need done, but the real specialness relative to other corporations, I was once told by a banker in a workshop for supervisors in Europe, that banks are very special because they convert people's savings into loans. And my answer was, every corporation takes people's money and converts it into some asset, so there's nothing special about converting funding into something. That's a balance sheet for you. So, but then here's what's important about what Martin Wolf concludes his review by telling you all to read the book. The model is intellectually bankrupt. The reason that this is not more widely accepted, the reason we lose is and he puts the politics first. The bankers are so influential, and the economics so poorly understood. And the poorly understood is really pervasive, including in the rest of economics. I was shocked to find, as a corporate finance person, how little corporate finance is understood in the rest of economics, especially even in fields like macrofinance that has grown since the financial crisis. They don't understand corporate governance. They don't understand corporate finance at all in that field. Opacity. This is after the crisis, and these are big shot people. Paul Singer, Elliott Management, was my teammate in Davos 2014, and he said, we do not know the risk of the banks. The disclosures are too opaque. So yesterday, Matthias flaunted all kinds of numbers. Market values are there to be observed. The rest of the balance sheet is by accounting, and good luck to all of us what these numbers mean. And so much off balance sheet and so much netting and derivatives, you can't understand the risk. The risk keeps changing. I understand about derivatives. The amounts, the notional amounts are many trillions for some of the active banks. And basically, Kevin Warsh, ex-Fed governor, also saying the disclosures obfuscate more than they inform. I cannot tell you who's healthy and who's not. The movie came out in 2015 based on the book The Big Short. And in the movie, which was, it was a feature movie, it wasn't a documentary, in this movie there was more emphasis on fraud. Okay, so there was this line in the movie about, I'll get people in jail and all of that, and the way it ended was why nobody went to jail, which is something we didn't really discuss. We discussed a civil case against some city group person at the very end of the book, where the SEC was pursuing somebody and didn't succeed. And the problem with this line is that most of what this book describes was lawful. So there was fraud too, but we were not paying attention to that. We just ignored that. We just said, well, obviously if they did, if there was fraud, they would have pursued that, and that was not our concern. Our concern was more about where the risk was falling than where the liability was falling. And so what I'm going to talk about in the rest of the time is more about where the liability is falling, okay, for corporations. So here's another book that came after the crisis about culture. This is a Dutch journalist who had a blog in The Guardian in which he interviewed people from the City of London. And he interviewed person after person from different parts of the financial sector, asking them different questions, and he put it in a book. And, there's more to say about this book, but this is sort of an excerpt of it in The Guardian, where he said, 7 years after the crisis, so this is 2015, after Lehman Brothers, it's often said that nothing was learned. And what he said the banks learned is that there's nothing they can't get away with. So they learned that they can get away with everything. So now we're getting to this, this point. Now, in 2016 or so, I basically abandoned 6 years of full-time lobbying on behalf of the public. It was a crazy time. You know, op-eds and petitions and comment letters to every regulator, FSB, Basel, Fed, you name it. Just trying to get people, academics, to help me. People were just moving on, but I didn't quite let go because I felt like it was my duty to do. So I spent my time doing that. It was, by 2016, there was actually nothing more to say or to do. I myself wrote another paper on leverage, which I really understood leverage a lot more, and especially in banking. And it was about heavily indebted firms, which is really the banks mostly. And for them, they can get away with it because the creditors are so passive, something that Matthias also presented. Also crazy, and we go back to it in the current edition of the book, is the subsidy of debt. Again, something Matthias mentioned yesterday. Why we subsidize debt over equity? No good answer. Bad policy, period. Now, I published then an essay in Journal of Economic Perspective in which I was beginning to be skeptical of whether financialized corporate governance, maximizing stock price, which is what I've been spending 20 years of my life teaching MBAs to do, was not going to be good for society if the law was not working. And in banking, the law was not working. So that was clear, okay? So I was saying here that there was going to be a conflict between maximizing the stock price and societal welfare. So now I'm kind of converging on the topic. And so governance, therefore, has to do with the governance of the government institutions, more politics, and governance of the private sector institutions. And so I'm going to try to set that up. Other things that happened, and I was beginning to pay more and more attention. In fact, for me, the one that really got the bug of what I'm talking about in the rest of the lecture turned on is Wells Fargo. So Wells Fargo was in my neighborhood. It was my bank. And it opened millions of accounts without permission. Now, what was that about? I was called to testify before a California legislature about Wells Fargo Bank. I had no idea what the issue really was. It wasn't in my exact bandwidth, this consumer fraud. And so what was it about? There was asked, what can California do about Wells Fargo Bank? In California, the person who first asked me this was the treasurer of the state of California, who's actually a customer of Wells Fargo Bank. So he couldn't do anything about it. And what could the state of California do about it? I didn't know about state law, federal law, which law was broken, what this was all about, who benefited, why they did it. But I got curious about it. So one of the things in this case that I'm beginning to get into the nitty-gritty of compliance and of enforcement is that corporations tend to investigate themselves. So there's a whole ecosystem of law firms that do these things. The companies come to them either when they had, when they had a problem or when they need to deal with the enforcers. Say, we will hire somebody. And that was actually the report I was asked to read for the legislatures in California. This 110-page report, written by Sherman and Sterling, a law firm in the US, as I'm reading it as an economist, I'm like, oh my God, that cost a lot of money to produce this report. Now, what was all of that about? In other words, what's the net present value of all of this altogether, that now they have to take up all these ads in the paper to say, trust us again, that now there are all these fines they're paying. What is going on? Why did they do this? And what are the consequences? And does this make sense? Now, in the report, what you can see, and you immediately can detect this, and I'm just a lay reader of this, what you can see is the report was written to excuse everybody who was still there, to lay a little bit of blame on a few people who were no longer there, and overall to protect the corporation. God forbid the corporation admits anything, because that would also bring private lawsuits and all kinds of things. And so it sort of said the following. There was a disinclination to view the problem as systemic. This problem about telling low-level employees to open 8 accounts per customers, 8 is great, they used to say. That was a saying in the company. There was a culture, okay? This pressure on low-level employee, which put low-level employees in the position of either being fired for opening accounts fraudulently or for not opening enough accounts if they couldn't have the sales skills to convince people to open more and more accounts, was already published in the Los Angeles Times in 2013. Now we're at 2016 when this is happening during the election fall of 2016, and this report was published in 2017. They didn't feel like seeing it as systemic. They didn't think why their low-level employees were opening accounts, so many, fraudulently. It wasn't convenient to view that. Instead, then there was obviously some securities fraud going on because they fooled investors about their success, on and on. Obviously, they defrauded the customers, etc. So there were consequences. Now, in general, banks and other companies pay fines. This is how it's dealt when they break law or cause harm. Okay, so some of it is toward harm, some of it is all kinds of things. In banking, in particular, this is 2017. They paid hundreds of billions of fines, but they made a lot of money. So it's kind of cost of doing business. They can afford it. Okay, so you drive fast, you pay the fine, you keep going. 10 years after the crisis, the New York Times had a whole insert called 10 Years, 10 Lessons from the crisis. And the 10th lesson was the last page of the print paper, which I still get on Sundays. You can't see it online because it left the entire page blank intentionally. The list of all CEOs that went to jail. Okay? This page was intentionally blank, the list of CEOs, okay? The perpetrators have not been brought to justice. This was a very, like in the movie The Big Short, a sense that some injustice happened. This is important because it actually fed some of the anger that we're seeing in our politics, okay? There was injustice. A lot of people suffered, and it wasn't the people who perpetrated this crisis and this recession. Okay, so there was a sense of injustice about it. The question is, what was it about? Did they commit crime? Didn't they commit crime? What was going on? Anyway, so if they didn't commit a crime, they wouldn't go to jail. So was it really legitimate concern? So I used to think that it, probably wasn't legitimate, that it was just a public anger expression. In 2021, I was asked to write another essay in a publication similar to Journal of Economic Perspective. It had a volume on capitalism, and the question asked of a bunch of mostly economists was, what has gone wrong with capitalism and how to fix it? And we were given 5,000 words for this. That's a tough question, and it presumes that something has gone wrong in the way they were asking the questions. What has gone wrong? My thesis in this was the following. What has gone wrong with capitalism is that the forces of capitalism, the way we teach it in the finance course in the business school and in the rest of the business school, have undermined, overwhelmed, corrupted governments in democracies, therefore harmed our democracy. And second point, deception is a tool of power in markets and in politics. You convince people to buy your product, you convince people to buy your ideas, your policies. Persuasion is a whole sector in the economy. PR people, lobbyists, marketing people. You get results. That's why you hire them, okay? You get results to change the law, etc. So that was my thesis, and I had some, now we come to the book, as doing it chronologically. Somehow, despite it being very traumatic experience for me, very traumatic, because it didn't matter whether I was right or not. I had no power about banking. Jamie Dimon had power, I did not, do not still. So the new volume of the book ended up coming in 2024. It was supposed to be 2023, but then there were all these crises. As the book was due in March 2023, we obviously had to keep it for a few more months and write about Silicon Valley Bank, First Republic Bank, Credit Suisse. The draft before that was warning about Credit Suisse because it was the zombie bank of the day. And zombie, by the way, I have numerous slides about banking. I will show them in Frankfurt and show them elsewhere. And one of the big slides is about zombies and the symptoms of insolvency, which the banks display all the time, including the intense hate of equity or the inability to raise. Anyway, the book grew by about 200 pages. It remains extremely cheap. In fact, I could put like a 30% off. So I urge you to maybe consider reading it. And I wish I had a lot of copies here, but their Brexit frictions mean that my publisher is very resistant to sending books into the continent. Apparently, it's very cumbersome somehow from Oxford or US. Anyway, so that's the two books next to one another, the paperback from 2014, the paperback from 2024. And what it did was we just left the text as it is, which goes through 2012, and added 4 chapters. So it wasn't like what they do in textbook where they want you to buy the new volume and the new edition and they keep mixing up the pages. Anybody who read the old one just needs to read the new one, the new pages. 4 chapters with the headline, Undermining Democracy and the Rule of Law. So we increase the coverage of politics and we increase the coverage of law, while also revising all the stuff that was in the book about leverage and resolution and all, Basel and all the stuff that was mentioned here. And in particular, so just to set the stage, my last word on banking here, on the topic of this book, you know, the emperor in the emperor's new clothes keeps marching down the street. So in banking, there are lots of emperors, there are a lot of people making flawed claims. That's what we call the banker's new clothes, flawed claims that don't have substance or are not valid. And there are many, many of them. By last count, we have 44 flawed claims, distinct claims that you hear people say, and something's wrong with them. And it doesn't matter how much time you said the emperor is naked, you know, they keep marching down the street. So it doesn't matter that we keep writing it because they'll keep saying it. Anyway, and then they'll hire the person to put an ad in a paper or in a podcast about that. So we now have a publication that we keep online that we keep updating. I think it's also an ECGI working paper. But latest from April of this year has 44 flawed claims. And that's the date in which I also wrote an op-ed called Nonsense and Bad Rules Persist in Banking, which is open access. You can find it on my website for sure. And it probably is the last op-ed I'll write about banking. I'm tired of the subject. But anyway, these are the epigraphs of the 4 new chapters. And so one is really, we expanded the coverage on central banks. So central banks were mentioned many times, but not explained as institutions in the original edition. In the chapter 15 here, we explain how central banks work, because oftentimes they are the mechanism of bailouts, but it's misunderstood the way their role they play in this system. It's not about monetary policy. The whole fight was, I refuse to talk about monetary policy and interest rate policy. This is about the interaction of banks with private sector institutions and governments, and sometimes as regulators. And they are important to understand as players in the middle between the government and the private sector banks. The chapter that I want to focus on in the rest of the talk is the last one. The last one is called Above the Law, and we put a question mark on it, which nowadays Martin Helwig likes to say, if we're on a book talk, that we should put an exclamation mark on it. Yes, some of the banks are above the law. This too big to jail that was mentioned here, it's going to come up. So the epigraph of that chapter was taken from an economist in the 1940s in Germany talking about power, saying, essentially, every day there's power struggles in the economy, and the people who win are those that have the most brutal and often subtle ways to gain power. It's not a word that economists like to use, or even any academics that are not like in sociology or some other fields like that, that, you know, we're somehow superior to over here. But it matters. That's what I learned anyway. Here are 3 books about some stuff that came up in the book that we were not aware of and did not cite. So we just discovered them in the summer after the book was done. One was on JP Morgan Chase, which we do take on in the book significantly, and I'll show you. It was kind of the American bank we took on repeatedly throughout the book. The middle one here, Banking on Failure, is about a scandal that we discuss in chapter 17 called Cum-Ex, which was in Europe. And the last one is called Too Big to Jail, a title of another book as well that I'll show you, and it was specific to HSBC. I want to enter the subject of corporations and rule of law, moving from banking with my choice example of a bank called HSBC. And here's a video. It's going to talk slower than I do, so you have time to relax for 2.5 minutes. This is the video.
Over the last decade, the largest international banks have been involved.
Think about the US case that you saw announced about charges against HSBC is this title, headline. UK intervened on behalf of HSBC to tell US to be please gentle with HSBC lest the financial Lehman moment, the financial system will collapse if you do a big fine or a criminal charge against HSBC. So you see the symbiosis between the UK government, where it's based right now, even though it's basically a Hong Kong bank and very planted in Asia, and how important it is to UK. JP Morgan Chase. There's a website with a lot of rap sheets of a lot of corporations in the US. This is, as of a few months ago, it paid nearly $40 billion. And I'm just going to talk briefly about one of the biggest fines that JP Morgan Chase paid. And just one point, we go through it in the book. $13 billion was considered the biggest fine of one institution at one time. It was to cover a lot of different things, and it was fraud, securities frauds and consumer frauds and mortgage fraud during the financial crisis, and it was by Bear Stearns and HBC and JP Morgan Chase and Washington Mutual banks that the JP Morgan Chase bought through the financial crisis. But Jamie Dimon liked to say that it's only these other banks that they bought together with their legal liabilities and not JP Morgan Chase. However, there was a case buried in there that you can see in the statement of fact, a very sparse statement that accompanies the settlement. And the statement was 11 very minimal information. And in there was a mention of a JP Morgan Chase employee, a female, because it says she submitted a letter telling her superiors and other executives in JP Morgan Chase that they were violating securities fraud by taking really, really bad mortgages, bottom of the barrel mortgages, and securitizing them and mis-selling them to investors, pension funds and others. These are the kinds of securities that crashed from AAA to, to nothing, okay, to default. Obviously, she lost her job. She had a non-disclosure agreement. Her name was not mentioned, but a year later, this was 2013, after our book came out, a year later she came out with her own name, telling the story of the fact that she told prosecutors a lot of information about JP Morgan Chase and about specific people inside JP Morgan Chase, and she wanted to testify against JP Morgan Chase and against these people by settling for $13 billion, which was an amount that was up from like $1 billion that Jamie Dimon was willing to pay the feds. They buried the case. The case was ready to be filed in California. She was in California. She spoke up because the statute of limitation was reaching, and she said, the prosecutors told me they'll pursue it, and they didn't. Now Cum-Ex. Okay, when I speak about Cum-Ex in the US, nobody knows what I'm talking about. In Europe, I hope you know that your governments in many countries in Europe were robbed by the banks. Robbed through a scheme in which multiple receipts for tax paid were submitted when only one tax was paid on dividends. It was detectable quite easily. It went on for 2 decades at least, okay? In the US, it was published in January 2020 as the biggest tax heist ever. And at the time, we didn't even know the magnitude of it. There is now a website called Corrective. It has estimates and stories from many countries, and you'll find Belgium there in the bottom. 7.5 billion euros were robbed out of your taxpayer. This is not shifting risk to taxpayers. This is stealing from taxpayers directly, okay? Germany was the biggest loser of taxpayer, 36 billion euros, followed by France and other countries. You'll find this, there were trials going on in Denmark and others. However, the cases that were starting to be prosecuted in Germany in 2012, criminal cases, and there's much more to say. We talk about it in the book, and there's much more to say about it. The prosecutor here, named Anna Boriker, resigned her position in April 2024, claiming that the German system was too easy on white-collar crime. She joined a nonprofit organization run by Gerhard Schick in Germany. So I want to go back quickly and re-examine all the assumptions I was making, we are making oftentimes in our teaching and in our research, okay? What we teach in corporate finance, Philip Bond will know, this is from the preface of a standard corporate finance book written by 2 of my colleagues. In theory, the goal of the firm should be determined by the firm's owners, treats shareholders as owners falsely. Shareholders agree that they're better off if managers maximize the value of their shares. So that's what we teach. So the standard view is that the corporation is owned by the shareholders. The shareholders should be the ones for whom the corporation does things. And the way you align is some kind of financialized compensation. We teach mostly about stock price maximization, not accounting profits, which are a creature of the accounting profession. In banking, they focus on return on equity, even crazier as an objective. We are all familiar with what Milton Friedman said, and I'm highlighting in yellow that he did emphasize that you make as much money as possible while obeying the rules of society, those in the law and those in ethical customs. So this was the big qualification on make as much money as possible while obeying the law, while being ethical, is what he said. So here's a cartoon. The planet got destroyed, but for a beautiful moment of time, we create a lot of value for our shareholders. This is an example of somebody who says, as a company, I couldn't care less about the climate. Of course I care, but my responsibility is not to care. And this is about natural gas. And the guy says at the end, this is a New York Times Magazine story, 2022, when we transition from fossil fuel, I'll be dead, so it won't matter, is what he says at the very end. So we have a lot of companies wanting to do good. We talk about them here in ECGI, but you also have this, okay? You have that. We have companies in the US that are polluting big time, that are putting forever chemicals in every place in the US, and it's lawful, okay? This is lawful but awful. DuPont, etc., there are some private lawsuits. It's a long story, but, these laws are not working, okay? We obviously have a lot of statements about how we care about everybody, commitments to ESG. This is 184 CEOs saying they care about everybody in August 2019. This is the Davos Manifesto, the purpose of the company, to create, engage with all its stakeholders, shared, sustained value creation, whatever that means, okay? But behind the scenes, you'll find the greenwashing that we were talking about, cultural washing, whatever, that BlackRock, tells oil regulator, don't worry about what our CEO says, it's just PR, et cetera, et cetera. So this is the kind of thing Babchuk talks about and others. Okay, back to corporations. So after this, went back to the beginning of corporations. What is going on, okay? In the history of corporations, obviously there's a Dutch East India, et cetera. What was the big innovation? Why are corporations the winning form that runs the place, runs the economy. So they started with very special purpose as extensions of the government, allowed to go do trades and do all kinds of things. Obviously, the English East India was running, the entire continent and have armies and all that stuff, as was the Dutch. In the US, corporations started by doing infrastructure and giving permission to do precisely this highway, this bridge, etc. Very specific charter, very constrained corporate law. Corporate law forbade one company from owning share in another company, no mergers, required unanimity of shareholders for any decisions. In other words, and there was ultra vires. If you deviated from your purpose, you could be shut down. You had to do just what you were asked to do. But it required an act of Congress, and there was a monopoly concern and all kinds of things like that. By the time we're at today, it's very, very easy to incorporate. You can incorporate for any nominally lawful thing. You don't have to say anything about what you're going to do. And you are very little constrained with the business judgment rule and everything about what you can do. So there is a lot of freedoms to corporations, which essentially put the pressure on the rest of the law to constrain corporations, okay? In Delaware, in the US, that's where they incorporate, but of course there are now much worse states, Nevada, Wyoming. Everything goes there. Anything goes there. You can go there and incorporate in an hour. You don't have to have an ID at all, okay? So the key feature of a corporation is that it's a person. It's not owned by anybody. It is a legal person, separate from all human beings. It's very important to understand. It's not an exclusive contract. It's not owned by shareholders. It's a person. It was a concession by the government to be operating as a separate person in the law. The existence and the legal rights are derived from governments and legal systems. So the corporation is a legal thing that lives in a legal space. That's the corporation. Obviously, there are people who run it, but it has a lot of rights. It signs contracts, it owns assets, it can have political speech rights, it can have even religious rights in the US. So that's all in the law. They go to court, they say, we deserve this right, this right, this right, we're people too, okay? They're people. They're legal people. This is a book about the Constitution in the US and how corporations gain more and more and more rights, not by marching on Washington, but by going to court and gaining more and more rights, some of which don't seem to make sense for corporations. We don't give rights to every person. We don't give certain rights to kids. So we should give them rights that affect why they exist at all in the first place. There's a lot of opacity. There's now a rule in the US, and there's huge outcry about beneficial owners and registering beneficial owners. But here is the circle. Corporations have gained many rights and they have many freedoms. And the question is who's liable and how when corporations cause harm. So we have laws for people. If people break laws, cause harm, stuff happens to them, what happens when corporations cause harm? Because they have a lot of things they can do and they can cause harm. Now, the laws that are relevant for corporate governance go much, much beyond corporate law, securities laws, which is our obsession in corporate governance research. There are the laws that enable corporations. So these are really the corporate law that defines, boards and shareholder rights and all of that. There are laws that give them the basic rights to own things. And then there are the basic laws that enable markets, property rights, contracts law, bankruptcy law, obviously, antitrust law are written for corporations, torts, tax. Okay, these are basic laws of markets. And then there are lots of other laws that try to protect people. And these people are often stakeholders of a corporation. The labor laws, consumer protection laws, all of these, anti-money laundering law, anti-bribery law, human rights laws, all of these laws touch the corporations sometimes, okay? Then you have specific sectors, banking and aviation, on and on and on, special laws. So corporations engage with a lot of parts of the law, not just with corporate law. Now, corporations not only interact with one law, but with many laws, because we have a global economy. So now, you know, this now touches on Curtis Milhaupt's talk. The geopolitical power of corporations, the symbiosis between corporations and their own home government. This is what played out in HSBC. This is what Curtis was talking about, you know, controlling shareholders, but also other corporations, okay? So they interact with lots of governments. Who has power? A multinational corporation. So now you see the battles. You see Telegram CEO jailed in France. You see Elon Musk fold in Brazil, you know, et cetera, et cetera. So enforcement and adjudication. You have enforcement of sports law, rules. You know, this is soccer for you. You know, you want a fair referee. Okay, so adjudication, control. A human rights example, okay? Human rights is something that many governments signed in the UN in 1948, okay? Now, here's a case for you. Chocolate manufacturers. Okay, so this is not related to supply chain, accountability, and all of that. In 2001, there was an agreement signed between lawmakers in the US and chocolate manufacturers to stop employing child labor in Africa to produce chocolate. And they committed within 5 years, no more child labor, or else Congress was going to have a law. So they will do it voluntarily, except for the heroes they signed, including Nestle. Except they didn't. So now you have documentaries coming years later, 2010, and a story in Washington Post, investigative, about continued child labor to produce cheap chocolate for us. What happened was that lawyers tried to use a US law called Alien Torts Act, which allows foreign citizens to claim damages in US courts. This case that started in 2005 went all the way to the Supreme Court in 2021. And in 2021, the Supreme Court decided in favor of the companies Cargill and Nestle, saying that the law applies to them, but the conduct was extraterritorial. So you can see how this can matter. Here's Elizabeth Pullman, one of the ECGI, at least member, if not fellow, and she writes a paper called The Supreme Court and the Pro-Business Paradox. And the paradox, she's saying, is the Supreme Court is not understanding how corporate governance actually works and what shareholders actually want, which could very well be ESG. They rule in favor of the corporation. Business-friendly. Corporation can make people sign mandatory arbitration. Corporations don't have to pay tort claims. Corporations can do all sorts of things. It falls then on the ESG crowd to take care of it, because the government doesn't, the law doesn't. That's what she's saying, puts the pressure on corporate law to deliver for society. Okay, and so she's saying the court doesn't even understand where the corporation exists even. The fact that the corporation resides in the US and the main decisions are in the US. Just because the conduct happened in Africa does not mean that the corporation headquarters in the US is not responsible for it. So when you unpack Milton Friedman, he is actually saying in the article that he wants free and competitive market without deception and fraud. So he is saying somehow or other this has to happen, and the contracts and the laws and the rules of society, in his language, have to protect everybody. That's what he's saying. And then go ahead and make as much money as possible. But what if? What if instead shareholders don't have impact? What if instead governments fail? What if instead corporations affect the law itself? What if instead they can cause harm with impunity? Therefore, what if instead making as much money as possible includes distorting the laws and law enforcement for the purpose of making as much money as possible? That completely undoes the entire recommendation, because their basic provisions don't hold. So now I come to two parts of governance. Internal governance is what we usually do here. How to align the participants inside the corporation with one another. And then whatever they do towards the outside is voluntary. okay? Or maybe it's subject to competitive pressure, as Philip was saying, or whatever. So this was supposed to be external. So external governance, the other side is external governance. External governance is society and the corporation and the people in it, okay? In other words, society being the government. Now I'm going to give you the true story about that. So the true corporate governance challenge, the way I frame it, is society wants to compel the corporation to avoid causing harm, compel it to do what it can do without causing undue harm, okay? And the corporation has a veil, a corporate veil, and then society has to control it. Some of these people have a role in the corporation, some of them don't. Profit sources, maybe innovation, maybe regulatory arbitrage, maybe misconduct. These new rules will fundamentally change the way we get around them, says this. Here's a lawyer saying a criminal is a person with predatory instinct, this is back 150 years ago, but without sufficient capital to form a corporation. But today, my formulation is many can form a corporation and then commit the crime with impunity. In other words, the other way around. So easy to form a corporation today, okay? Above the law was the epigraph, and here is the view from a robber baron. Law. What do I care about the law, said Cornelius Vanderbilt. Ain't I got the power? Above the law. That's what he's saying. He is above the law. So Too Big to Jail is another book written about the US, and other books were written to make the point that we have an under-enforcement of the law on corporate people. We don't enforce, okay? So now I have one article on hold with Greg Buchak, my colleague, in which we did present in an ECGI conference a while ago, but we did not post it for reasons I can talk to you about. What we show is that corporations, that shareholders have more power in the law, and governments do, but other people have less. So it's strong managers, weak owners, as Mark Rose said, weaker yet everybody else, okay? So the shareholders are weak, but everybody else is even weaker. The law, when it comes to corporations, is different in different countries. Whether a corporation can be criminally charged is yes in the US, under some conditions, virtually no in Germany, and a qualified yes in some countries. But even if it can, this is a book about law enforcement in Europe, again, about managers. It's somebody in Luxembourg. There was somebody he's now in Luxembourg. And here's a recent article about European liability laws for corporations, saying that there's weak liability in Europe for corporations. But this is compliance week, so it's a publication for compliance officers. Not to worry, it's not going to change anytime soon. In Germany, they proposed more and more laws. In Germany, the maximum fine for corporation, for anything, is 10 million euro. No matter how big it is, no matter if it's Volkswagen, okay? So here's Luigi saying that, you know, in an address that we academics fall for finance, even though it's not. It's often rent-seeking. This is a risk manager in a major financial institutions, Citigroup, it has many employees, telling me that academics are the problems because they reverse engineer stories for banks. Here is a SEC ex-commissioner saying that the lawyers, I didn't want to just talk ill about finance people, but talk about lawyers, that lawyers, corporate lawyers, have a can-do attitude, and there's no accountability for them. I can talk some more about this, but this is the paper I just want to highlight. It's not posted yet. It's being written as we speak. Why good corporate governance is not always good says the following. I want to present to you here. Governance is always about power, information, and incentives, and I want to present to you the biggest picture. There are layers of delegation, starting with society, to government, which is democracy, okay? From government to the corporation, which the law should somehow give some constraints on, or enable and constrain, from corporation to the board, to the manager, and obviously the rest of the corporation below. So it's not inclusive, but it has all these different layers of agency problems. In the paper, we do 3 participants only. Society, which we equate with government, corporation, which we equate with board and shareholders, and manager. And now we have potentially layered corporate governance, which you can say external deals with government and the corporation, or society and the corporation, and then the corporation does the internal, and everything is fine. If the external works on the corporation, then the corporation and the manager are aligned as well as you can in both cases, subject to the frictions, and then therefore we can focus on internal governance. It's a kind of transitivity thing that if it works, it would justify corporate governance research doing mostly internal corporate governance. But what I want to argue to you is that this is not true. I'm going to have to skip most of the slides. I'm just going to flash through them. I'm happy to post them. This is the way corporate enforcement works. The Department of Justice in the US is saying, we want to fine corporations and we want individuals. So what they're saying to the corporation is, give us individuals and we will pursue them. Okay, they're not doing their own investigations. I'm going to give you very brief non-bank corporations. Obviously, Purdue Pharma. I mean, it would be the example. I started with banking, so I started with HSBC, but you don't see the people dying from the drug cartels of there. But in the case of Purdue Pharma, they're often time again, Purdue didn't stuff the drugs into them, but Purdue convinced the doctors and them to take these addictive drugs. The company was privately held. It had a controlling shareholder, the Sackler family. The Sackler family took a lot of dividends out and then filed for bankruptcy with the harm to US society measured in the trillions that there is no way Purdue will ever pay, okay? There is a plea bargain in 2007 that could have stopped this and didn't. It was a big failure, okay? Now the bankruptcy was thrown out in Supreme Court in the US. I'm gonna have to skip PG&E, it's my local utility. The interesting thing about PG&E is that it was convicted in a jury trial of crimes based on a 2010 explosion, okay, for neglecting their gas pipes, okay? And it was fined only $3 million, and it got a monitor, a probation monitor. Then it started having all these fires and filed for bankruptcy. While in bankruptcy, it pleaded guilty to 84 charges of manslaughter. This is a crime, a felony crime in the US, for which a person would get 90 years in jail, at least if they got the 1 year plus per. No individual in PG&E paid. The fine was minimal because it's a utility, monopoly utility. Meanwhile, all the hedge funds, and meanwhile, it came out of the probation with absolutely scathing report by the monitor. Boeing. The plea bargain with Boeing was quoted by John Coffey as one of the worst deferred prosecution agreement he ever saw. And in this agreement, so I'm going to skip through it, there was also a derivative suit. So, shareholders can sue in Delaware against the board on behalf of the corporation. And Boeing shareholders dared to say that they were victimized when the corporation endangered passengers on their behalf to compete with Airbus. And shareholders got $237 million. From whom? From the board? Nope. From the insurance of the board. That's how it works. And they threw a test pilot under the bus. They gave the Department of Justice information violating, lawyer confidentiality, and the test pilot was found not guilty. after more whistleblowers and more doors flying out and more violations, Boeing was now charged again and pleaded guilty again to charges and paid more fine. I have one slide on Volkswagen. Amazing case, okay? I'll post this. So the insight from our paper coming up, please watch for it. In the intersection between internal and external corporate governance, if you align shareholders with the corporation or with shareholders, you might exacerbate societal harm if enforcement is weak on the corporation. It's pretty obvious. The corporation will pay the manager, indemnify the manager to do the misconduct on behalf of the corporation, and will undermine external enforcement on the manager through the insurance, through paying for lawyers, through creating deniability for the manager so that the manager will do it on behalf of the corporation. We also show that these rewards they give to corporations for voluntary compliance, for throwing people under the bus, and self-investigation, which corporations do, can backfire because they make it very transactional, and because they're voluntary, the corporation will do them and in order to get the discount. So we show that we have even math in an appendix, a lot of examples. And so what we end up recommending is more resources for enforcement, whistleblower protection, more transparency, and intervening in corporate law to the extent of preventing the corporation from interfering with law enforcement on individuals when appropriate. So, in fact, Delaware courts decided to disallow insurance when directors are reckless, but Delaware legislature, which loves corporations incorporating in Delaware, allowed the corporation to insure themselves. Okay, concluding remarks, political economy. So in this talk, I started with bad laws, and I ended with bad enforcement, or imperfect enforcement because of the frictions, okay? And the frictions could be because the corporation is too big to jail, meaning collateral harm or whatever. But the political economy of legislation and of enforcement undermines societal corporate governance, which is the corporate governance that really matters, however we do it. If we do it separately, external, or if we do it somehow more holistically. Current approaches to external and internal governance are often backfire if misconduct is profitable for the corporation and enforcement is weak. Focus on internal governance while ignoring external governance is misguided. Holistic perspective offers vast research opportunities if you focus on the different parts of the law. It plays differently in different parts of the law, just like it plays differently in banking. So there is a rich research agenda when you take a holistic approach to corporate governance. So I love everybody doing well and wanting to do well voluntarily, but it always lives within a legal and framework. And it always responds to it because that's how it works. Incentives do play a role. So that's it. Thank you.
So thank you very much, Anat. I think we normally do think about the delegation from owners to boards, and then from boards to managers, and in some countries, of course, employees also delegate to boards. And I think what you brought to us is the second delegation, namely the political science of it, namely that corporations are, of course, creatures of the state. Yeah. They enjoy this enormous privilege of entity shielding and legal personality, and that doesn't come about just by chance. And I think you've opened up a whole new area of discussion and debate for us, and your examples are, of course, extremely striking. Now, we are basically out of time, but let me, I'm sure that we'll have one or two questions that people want to ask. Yeah. No, I'm going to give the guy now to Guy Jubb.
Where's the other one? Oops.
Anat, thank you very much for the question. My name's Guy Jubb. I'm a director of the ECGI. I'm neither an economist, nor an academic, nor a lawyer, but I am a chartered accountant. And one of the players that you did not mention explicitly in the tapestry that you described so graphically, other than excluding them in terms of the big picture, was the role of external auditors. And I used to be an advisor for 2 terms to the PCAOB, the US audit regulator. I would be fascinated, given your interest in this, and you referred to the opaqueness of, I used to be also a professional investor, and the annual reports were just so dense that they were of HSBC that they could not be read. Bottom line is, what do you think that the role of external audit in particular is fit for purpose in the current capital system?
No, so I'm the one who asked about auditors already in the discussion of the new disclosures in Europe. And in this conclusion here, which was sort of the policy version, the last one on policy says effective governance requires more public resources and legislation to change potentially, the liability bar for responsible officers. There is this law in the US, it's a strict liability responsible officer law, but it can be expanded, and there's a whole other discussion we can have. But here it says specifically, reduce external enforcement frictions, including whistleblower protection, transparency, gatekeepers rules. So by gatekeepers I mean auditors, lawyers, credit rating agencies, the external gatekeepers, especially auditors. So every single class I teach now to MBAs or undergraduates always has auditors. And so auditors on the financials, but also auditors on anything else that gets claimed or committed to supposedly. How do we know? Yeah, unless it's observable and somehow enforceable, is very important. So, I didn't have time to give all the examples, but Wirecard, Carillion. We, at least in the US, have a regulator for auditors. I can tell you that a very high-level official in BlackRock was unaware of the existence of PCAOB, the Public Company Accounting, the regulator of auditors attached to the SEC. Yes, so that's the opacity I started with, which Michael Lewis talks about in the banks, but it's true also elsewhere. And even rules like Sarbanes-Oxley, which say that the CEO, CFO have to sign on statements, the small print says, they sign that to the best of their knowledge, the statements are okay. And it has clawback provisions. But the clawback only applies if the accountants restate the earnings. Guess what? They never restate the earnings. They'll fix them for later, but they never restate. Therefore, the clawback provision is hardly ever enforced.
Yeah, Guntram Wolf, Solvay Brussels School. I have 2 questions. One is more specifically on the US and the recent Supreme Court decision to put the president under certain circumstances above the law. Perhaps you can say a word about that and what it means for the problematic you discussed. The second is more specifically, I would say, on lawmakers. We live in democracies with the assumption that, voters vote for their interests, right? And if they vote for their interests and lawmakers are corrupted, they should vote them out of office, right? And this is the essence of democracy. And basically, you are saying, well, that doesn't work, right? And if you're saying that, are you saying that democracy is not working, right? I mean, that's, I think, the ultimate question that you're posing, right? And
That was my-
so the system question immediately comes when
Yes.
when listening to your
Yes.
discussion, and I guess the question is: do we think of other systems that are better than this one, or what's the sort of the end point of what you're saying?
Thank you. So now you have books, and my thesis has been that there is a crisis of democracy and a crisis of capitalism, and they're intertwined. So Martin Wolf called it the crisis in democratic capitalism. So there is a lot of writing to that nexus, that democracies have become weak, and look at the rise of China, etc., to say what happened to our democracy. So what happened was, and that's why the second part of my thesis in the Oxford Review of Economic Policy was that voters get manipulated, just like lawmakers get manipulated. In other words, you know, the sort of way in which democracy works in free speech countries. In other words, you can go to jail for telling the truth in some autocratic regimes, but, you know, free speech can get everybody, you know, off, you know, into whatever, alternative facts. What do they call it? You know, post-fact. We don't agree on facts. So democracy, you know, what you saw, what you're seeing in the US, and, you know, what you saw maybe in Brexit too, is voters were being lied to. Voters are being lied to right now in the US and maybe elsewhere. So it's a problem of democracy that, you know, people from the beginning of democracy were worried about is how does the public get informed, even about their own preferences, which is why it's sort of behavioral, what I'm saying about consumers in markets and about voters in the polls, that we need informed citizenry. I wrote my book to explain about leverage to the average citizen or the journalist, and I can't get through.
Yes, well, thanks a lot for a very, very interesting talk. I think you were quite persuasive about, at least in all those cases, and there are more, the ability of indeed corporation to abuse the common good because of these external rules and the fact that, you know, you have competition between 50 states about incorporation, the fact that in general you have these huge corporations that can play one country against another outside the US also. Now, so your point about trying to come back to ECGI and the research we are meant to do on governance, I think your point that taking more seriously the external environment is very important when we look at internal governance. But should we, because at some level, listening to you, should we be just more pessimistic and say, look, given the way in which these external rules are so crazy, in a sense hoping that internal governance can really help? Is that doomed, or should we be more optimistic? And what kind of research would you recommend in this?
Thanks for this question. I think it depends. I think in some areas where the law is particularly weak, then internal governance can be harmful. Good internal governance can be harmful because you're aligning the manager and the corporation to harm. In other areas of the law, you know, so it really depends. There are so many parts of the law that we're talking about, and in each one of them, stakeholders play out a bit differently, both in terms of the way the law is written and about the way the law is informed. So what I'm saying is there isn't just a one corporate governance. There is corporate governance as it interacts with all the other laws. And that's what I'm basically driving to, that research in governance will be more attuned and more split off to, you know, here was, you know, a paper on, you know, ESG and competition or whatever, but, you know, there are papers like that. There are papers about, you know, contract law and, you know, should mandatory, you know, so in other words, how does it interact with labor law, with contract law, with bankruptcy law? I can talk to you about insolvency laws and how they can be used to, you know, do litigation management, all of that. So, you know, all kinds of laws. In the US, they had to go and have a law specific to sexual harassment to say a corporation cannot make people sign that they will not sue the corporation, that they must go to mandatory arbitration for sexual. It's a contract law issue. By the Supreme Court deciding that mandatory arbitration was allowable in contracts that were very much between unequal parties, like an employee in a corporation or a customer in a corporation, it gave the corporation power, excessive power over these stakeholders as they signed these contracts. So it depends, is my answer, that I think corporate governance research cannot just obsess all the time about, dual shares or any of that without a broader look at the context in which these internal governance mechanisms play out. So, that's why there's such a rich agenda, because as you interact with all the laws with internal governance, they'll play out a little bit differently. So that's why it's very rich.
Now, it's also possible, of course, that good internal governance helps improve external governance.
It could, rather than undermine.
Because corporations have an interest in actually operating in functional states. So it's actually a very
corporations, for example, really like anti-bribery laws because they don't like to pay bribery. It's a way for them to commit not to compete to bribe. So they collaborate more with, Foreign Corrupt Practices Act than they collaborate with anti-money laundering. In money laundering, it's the government's fault. Governments love dirty money. It's a fact. UK and US, the most. And we don't have any experts on money laundering. I was shocked to discover there's no experts in law schools about money laundering. It's amazing.
In any case, I think, Anat, so thank you. I think you've opened another new set of debates, but to recite Matthias de Vatripon, governance stays important, and we have to ask, where are the research questions here for ECGI? But I think we've started having a debate about, where those are. So thank you again,
Thank
Anat.
you so much.
So the lecture and the materials will be on ECGI Global. As I said this morning, we're an open access platform, so all the material will be there for you free of charge. But you can also buy a copy of Anat's books. But her research paper is going to be free of charge. Thank you for attending this event combo. I hope you enjoyed it. And we hope to see you again soon, and at the latest at our next annual meeting next year, location and time to be announced soon. Thank you very much.